Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Have you ever noticed how sometimes things just happen to fall together on their own? How two things that aren't really connected lead to something else? Well, there's a word for that, and it's called serendipity. In 1943, naval engineer Richard James was working on a project to create springs that could stabilize sensitive instruments aboard ships. He accidentally knocked off one of the springs off of a shelf, and he observed how it walked down instead of falling. And that inspired the creation of the now famous slinky. In 1968, Spencer Silver, who was a scientist at 3M, was trying to develop a super strong adhesive. But instead, he created a low-tack reusable adhesive. Years later, his colleague, Arthur Fry, found a use for it. He applied it to the bookmarks that he used in his hymnal, and that led to the creation of the Post-it note. Well, today we have a similar situation, and if I were Judge Glanville, I might just be recognizing a shot across my bow. The subject of the serendipity involved in this instance has recently been in the news. Christina Peterson may have felt that she really had nothing left to lose the other night when she got into an altercation at the Red Martini Lounge in Buckhead. You see, she had just lost the primary for the judicial office that she was currently in, so her term was going to end in December of this year. So I guess she must have gone out drinking with some friends, and the police say that she was physically violent, pushed and punched an officer, and was arrested for felony violations, assault, battery on a police officer.
I got it. I can walk on my own. Don't touch me. Don't touch me. You a lie. You're a liar.
I'm telling you what I'm telling you.
You're a liar.
A judge really ought to know better than to argue with a police officer. Now watch this. This is what she got in trouble for. Well, Peterson has a different story. She was trying to break up a fight by pushing a police officer away from the fight that he was trying to break up. You know, alcohol makes smart people stupid, and it makes stupid people stupider. And stupid people tend to do stupid things. And that's what happened. Well, the media in a lot of these news stories were referring to her as Judge Peterson because at the time she was a sitting judge in the probate court. But she isn't any longer. And the reasons might very well make Judge Glanville just a little bit queasy. So this is the opinion that was released yesterday, an inquiry concerning Judge Christina Peterson from the Georgia Supreme Court. And it is per curiam, which means no particular judge signs it, but basically that all the judges agree. We have explained before that the judiciary's judgment will be obeyed only so long as the public respects it, and that respect will not long survive judges who act in a manner that undermines public confidence in their judgment and integrity. Judge Glanville, are you paying attention? So what did our judge do here? Well, she did a couple of things. There were 4 separate instances that she was charged with misconduct, but only the first one and the last one apply to us here. And I'm going to go through those real quickly. So here's the background and procedural history. She was admitted to the bar in 2013, and on March 5th, 2020, after 7 years, she was qualified to run for the office of Douglas County Probate Court and therefore became a judicial candidate. She was sworn in for a 4-year term on December 29th, 2020. In September 2021, less than a year later, the JQC filed formal charges against her alleging several violations of the Code of Judicial Conduct. They amended those charges in February of 22, alleging 50 counts of misconduct. The director dismissed 20 counts before and during the final hearing, which was held over the course of 7 days in September of 2023. The hearing panel issued a report and recommendation finding that the director had proved 28 of the 30 counts. And that's what the court's going to find. They said that those counts relate to 4 separate matters, which include Judge Peterson's handling of a criminal contempt matter, counts 31 to 34, her conduct toward county personnel, conduct during a meeting of her neighborhood homeowners association, and her petition for a year's support. The director has met her burden of proving that Judge Peterson's conduct with respect to each of the 4 matters constitutes at least one constitutional basis that authorizes discipline, either willful misconduct in office or conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. Finally, after reviewing all of the conduct underlying Judge Peterson's numerous violations of the Code of Judicial Conduct, we assess the proper sanction. On that point, we agree with the hearing panel that removal from office is the appropriate discipline here. So the first thing that she did was she handled a criminal contempt matter. Now, this is really, really odd because it almost dovetails perfectly with what Judge Glanville did. Judge Peterson handled a criminal contempt matter. This woman who was born in Thailand, had a Thai birth certificate, brought the birth certificate in, and she was trying to amend a legal document. So basically what she wanted to do, she had listed her father's name incorrectly on her marriage license application, and so she wanted to fix that, and she attached a copy of her birth certificate, which had been translated from Thai into English. And the copy said that the document was not recommended as a legal document. Well, when Judge Peterson got that, she set up a notice of trial or hearing and said that the petitioner was required to attend in person and that court reporting services would be provided only if the petitioner arranged for them. Now, basically what that means is that unless you pay to have a court reporter come in and transcribe this hearing, well, the state's not going to pick up the cost of that, and as a result, there won't be a record of what was said and what was testified to in that hearing. And it strikes me as a rather odd situation, but apparently this does happen inside the court system in Georgia, that you can compel somebody to bring their own court reporter. Again, it doesn't seem to make a lot of sense to me because I would think you would always want a record of everything that was said in the court. But Georgia does things a little differently. So the notice didn't tell her that there was any chance that there would be a contempt citation or that she needed to have her lawyer present. Judge Peterson concluded that the document that she presented was fictitious, fraudulent, and forged. The petitioner explained to Peterson that she previously listed her uncle's name rather than her father's name on her marriage license application in 2016 because her father was not involved in her life and her uncle had raised her. Judge Peterson ultimately determined that the petitioner was trying to defraud the court and held her in contempt. So, during her testimony at the hearing panel, Judge Peterson repeatedly referred to the alleged document as the translated birth certificate, a copy of which was admitted into evidence. When the hearing panel asked Judge Peterson what aspect of that document led her to conclude the petitioner was defrauding the court, Judge Peterson said that the hearing on the petition to amend, the petitioner admitted under oath that this was not her birth certificate and that she was trying to assist her mother in immigrating to the United States. The hearing panel then pointed out that Judge Peterson's contempt order appeared to refer only to the petitioner's marriage license application as false, not the birth certificate. And then Judge Peterson responded, as is written there, and it's pretty clear that the judge was either confused or was attempting to mislead the panel. Judge Peterson sentenced the petitioner to the maximum allowable term of incarceration, contempt, for 20 days, but allowed her to purge herself of contempt after serving 2 days if she paid a $500 fine. After the petitioner served the 2 days and paid the fine, she was released from custody. The hearing panel found that Judge Peterson provided neither a firm nor proper basis when she held the petitioner in contempt, and without explanation or justification imposed the maximum term of incarceration plus a fine. It determined the petitioner who testified before the panel was in good faith trying to correct what appeared to be an innocent mistake born out of ignorance rather than ill intent. So, essentially, they credited the petitioner's testimony over Judge Peterson, and they expressly discredited her testimony that she had not concluded that the petitioner had made fraudulent representations before issuing the notice of hearing. And that, again, from the gestalt of things, just doesn't sound like that's the truth. So they determined that she violated Rules 1.1, 1.2a, and 1.2b of the ANJA and Rule 2.2 of the Code of Judicial Conduct. And they go through that. Judge Peterson made an unsubstantiated finding that the petitioner was somehow attempting to defraud the court and then unjustifiably held her in contempt and then lied about the basis for her contempt ruling. Peterson purposely issued the notice without advising the petitioner that a criminal contempt charge on the allegation of fraud would be adjudicated at the hearing so that the petitioner would be unprepared to defend herself when Judge Peterson summarily found her guilty of criminal contempt. It is well established that criminal contempt is a crime in the ordinary sense, that you can't do that absent due process. A judge may announce punishment summarily and without further notice on hearing when contumacious conduct occurs in the judge's presence and threatens the court's immediate ability to conduct its proceedings. But where it's committed outside the judge's presence, due process requires the alleged offender is entitled to notice and due process. Thus, a person being tried for contempt related to an act committed outside the judge's presence or indirect contempt must be advised of charges and have a reasonable opportunity to respond to them. Since the petitioner filled the application out and submitted it to the court more than 5 years before being ordered to appear for a hearing, as discussed above, the hearing panel discredited Judge Peterson's testimony to the contrary. Thus, before holding the petitioner in contempt, she was required to advise the petitioner of the charges, provide her with a reasonable opportunity to respond, and permit her assistance of counsel and the right to call witnesses. None of those foundational process protections were given to her before she was sent to jail for 20 days. So that's the first thing, and it does sort of match up pretty well with the issue in the YSL case. Although Judge Glanville claims that the contempt was committed in his presence by refusing to disclose something, that disclosure was prohibited under the rules that govern attorneys, and Judge Glanville knew or should have known that. So again, it's not precisely on point, but this is strong enough language in here that Judge Glanville really ought to be a little bit worried about that. And here we have noting that Judge Peterson testified that she knew the difference between direct and indirect contempt because she'd researched the issue. The hearing panel determined that Judge Peterson knew the procedures she employed failed to meet due process requirements when she predetermined that the petitioner committed criminal contempt. So then we move down to, I think it's page 50 or 49 in this opinion, and it talks about the handling of a petition for a year's support. Now, Georgia has an interesting part in their probate court about petitioning for a year's support. So when husband and wife are married and the wife survives the husband, they take a look at all of the things that are in the estate, the checking account, the savings account, all of the personal property, all of that sort of thing. And essentially, before they pay off any creditors, they set aside an amount of money for 1 year's support for the spouse, which is essentially a way to give her time to adjust her income and outgo, as well as perhaps find a job. So that's a very important petition under Georgia probate law. So here's the long and short of what happened in this case. There's this petition, and the spouse files this petition for a year's support, and one of the people is an out-of-state party, the daughter of the decedent, and she's entitled to get notice. So the clerk sent her by certified mail this notice. It was signed for by somebody else, and eventually Judge Peterson found a way to get in touch with her, and the clerk and the daughter then spoke by phone. Chief clerk asked about the status of the original document and the filing fee, which were both required for filing. The daughter said she'd mailed the filing fee. The clerk assumed it was lost in the mail and ultimately took payment from the daughter over the phone and filed the caveat on July 14th, 4 days after the July 10th deadline. None of the chief clerk's communications with the daughter included counsel for the petitioner. So again, the ex parte rules say that you can't have the substantive conversation with a party without the counsel for the other party being present and part of those conversations. And if the judge can't do it, she can't have an agent, in this case the court clerk, do it. Her job is to supervise that court clerk. So the only way that communication is lawful is if the petitioner's counsel is on the phone at the same time listening in. The hearing panel found that although Judge Peterson's staff, including the chief clerk, knew that ex parte communications with parties to a proceeding were prohibited, Judge Peterson clearly failed to conduct proper oversight to ensure the chief clerk was not participating in such communications. And then they charged her with violation of the rules 2.9a and B and 2.9d because she considered the information that came in through ex parte communications. And of course, they cite the rule: judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. Where circumstances require for scheduling administrative purposes, that's not at issue here. Judges may obtain advice of disinterested experts, not applicable. Judges may consult with court staff, court officials, not applicable. Judges may, with the consent of the parties, confer separately with the parties to mediate, didn't happen. Judges may initiate, permit, or consider ex parte communications when authorized by law to do so, like search warrants and arrest warrants and that sort of thing. So they first turned to the alleged Rule 2.9 violations. Judge Peterson permitted and considered ex parte communications. That's a Rule 2.9a violation. By failing to promptly notify petitioner's counsel of the second notice, that was a violation of Rule 2.9b. And by failing to provide proper oversight of her own chief clerk, she violated Rule 2.9d. So all of these things, all of these violations that Judge Peterson is being hit with here in this particular proceeding, are so very similar to what Judge Glanville did by meeting with the parties without disclosing that he should be very nervous. If the Judicial Qualifications Commission files a complaint and conducts a hearing, there's absolutely no reason why the Supreme Court wouldn't find exactly as they did here. So that's what I have for you today. I thought you might be interested to hear how close this was. So yesterday, my wife and I went up to Noonan, Georgia, which is a suburb of Atlanta, down a little ways. It's a little bit south of Atlanta. We went there to go look at some countertops for our kitchen. They dropped our countertop and broke it, so now we have to get a new one. And so we went to the place where that was the case. But before we went to do that, we decided we would go to one of our favorite places up there, which is called Sprayberry's Barbecue. And anybody who's familiar in the Atlanta area with Louis Grizzard would know Sprayberry's Barbecue. It's not a big place, but the food's very good. And there was a young lady, a little redheaded girl, I think her name was Caroline, and she was just the sweetest person. She got to us quickly. She got our food quickly. And I noticed she had like about 12 tables. I don't think that girl ever stopped moving the entire time that we were there. So I dropped a $5 bill on the table. That was well in excess of the 20% that is normal for tipping. And then I added a couple of dollars more when I paid by credit card at the checkout register. Because when people do give you really good service and they work hard, they deserve to be recognized and rewarded. And then last night, because we were gone all day, we decided to go eat at Del Taco, Taco Tuesday, so we went for Taco Tuesday. And as we're walking out, I yelled back to the people in the kitchen staff who were preparing the food, and I said, you guys did a really good job. Food was really good tonight. I think it's really important sometimes. It's okay to tell your server, you did a good job, but they aren't the ones preparing the food. And if you have the opportunity to tell the people who are preparing the food what a great job they did, that also counts for something. And it makes their job just a little bit better that day. And when we can all do things like that, kindnesses for other people, it makes the world a better place. So that's what I have for you today. If you have any questions, drop them in the comments down below, or you can email me at the address above. Like, share, subscribe, all that stuff. And then after you do a kindness for somebody, come on back down here tomorrow and join me at the beach, and we'll talk about something else fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.